Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents, baby. Back at it again, May 23rd, Supreme Court order, U.S. DOGE service v. Citizens for Responsibility and Ethics in Washington. All right, so this one has to do with a lawsuit filed by the Citizens for Responsibility and Ethics in Washington, CREW, against the Department of Government Efficiency, DOGE. The lawsuit seeks to access to internal records under the Freedom of Information Act, FOIA, and the Federal Records Act, FRA. Basically, CREW is trying to uncover details about DOGE's operations, including mass layoffs, agency shutdowns, and budget cuts implemented during this administration. This is where we get to the central issue of the case. Does DOGE qualify as a federal agency that is subject to FOIA and FRA requirements? CREW's position is that DOGE functions as a federal agency because it exercises significant authority and makes operational decisions, thus is subject to FOIA and FRA requests. DOGE's position is that it is merely an advisory board to the president and therefore exempt from FOIA and FRA obligations. In April 2025, U.S. District Judge Christopher Cooper ruled that DOGE likely operated as a federal agency, citing its substantial role in government restructuring. Thus, he ordered DOGE to process CREW's FOIA request promptly and to preserve all relevant records. However, on May 23, 2025, Chief Justice John Roberts issued a temporary stay on the lower court's order, allowing time for the Supreme Court to consider whether to take up the case. So, at this point, DOGE has no obligation to comply with FOIA requests. And this case addresses important questions about government transparency and accountability. And the outcome could set a precedent for how entities like DOGE are classified and regulated under federal law. So we will keep an eye on this one and keep you updated. Kaimo, keep your mind open, do your own research, form your own opinion. See you next time.